Well, Henshaw here again, another one of my current event YouTube videos. And this one is on current California Proposition 25 out where I am in the Bay Area. But the issues are the same in every other jurisdiction. And this proposition wants to do away with cash bail and rely on quote unquote risk assessments. Now, that's fundamentally a lot better than cash bail, and for a number of reasons I'll be discussing. But that said, the courts don't have any jurisdiction of any statutory enactment of the legislature here because they're all bills of attainder, taking a life, liberty, or property without judicial process. There's not a judicial court anywhere in sight in California, although we know that there should be, that the Constitution mandates them, yet they're nowhere in sight. That said, cash bail is a bargain bonanza for all these damn people that post your bail for you, and then get you to sign contracts and this, that, and the other. And if you skip out on a quote unquote willful failure to appear, which is impossible in a court without jurisdiction, they can come after you. They can send the posse comitatus out after you for an armed arrest. And I probably have a summary remedy to recover all the money they quote unquote posted for bail. And this is bad enough to start with, but think about it, because the money quote unquote that they're using, they're able to pull out of thin air, like the New York banksters do and the Federal Reserve. And all they do is discharge the obligation for bail. They don't pay it because it's impossible to pay debts. Congress of the United States has declared it against the public policy of the United States to pay debts, HJR 192. So it can't be paid. So not only that, but they're using undefined dollars, a situation I've discussed in other videos. And if the dollar, quote unquote, is defined at all, guess what? It's by the president acting as commander in chief of the armed forces. And Lord knows how Congress managed to delegate authority to the president pursuant to their duty to coin money and set the value thereof, Article 1, Section 8, Clause 5. And yet there it is. And if you don't know, it comes from 12 U.S.C. 95A and B, the Federal Reserve Act of 1913, that allows the president, in effect, to declare one after another pretended state of emergency, which they've now done for, in effect, 85 years. Going back to 1933, FDR, and all the horse hockey that went with the New Deal, which they didn't bother to tell us was composed of a deck with 54 jokers in it. But if that's true, and the president's acting as commander in chief, that's federal, regional, martial law rule, and or it might be admiralty jurisdiction. But in either case, in the former, martial law rule can't be declared unless there's a known declared state of rebellion or invasion by which the writ of habeas corpus can be suspended. Admiralty jurisdiction, state courts are barred from exercising Article 3, Section 2. So where the fuck are we when we're in one of their courts? We don't know. What we do know and can prove is we're not in a judicial court exercising the judicial power of the state admitted into this union, which is exactly where we should be from day one. So all of this has to change, and this is a great opportunity, at least in California, to make a good start on seeing it end. And then if you can't post bail, then you have to stay in jail for as long as it takes them, to get you to a pretrial conference and a preliminary hearing, let alone a trial, quote unquote. And my Oakland case, which is a 14 felony case, we got dismissed on a time served plea deal. The kid was in jail for a year without even a preliminary examination. Whole thing was a joke, and we're going to make him pay for this one, and in spades. I'll keep you updated on progress on that. That said, there's just no possible reason to be in jail on bail. It just doesn't work that way, and it wasn't designed to work that way. And not only that, by setting bail, they presume two things: one, that you're guilty of the offense, and two, that you're a flight risk. Now, in my case, neither of those two things is true. And I have never posted bail except for the one time years ago I got arrested on Memorial Day weekend. And I would have been, thrown in jail for the entire weekend and would have lost my job at the airport, which I subsequently did anyway. But knowing that, what I did was I did post bail under extreme duress and coercion, and never got it back, by the way. Story for another day. But the end of that case happened when I ended up getting the good old directed verdict of guilt and got convicted for a traffic crime. And I went down later with my sweetie with some rolls of quarters and offered to pay the fine, but I told him I didn't know how much it would take to do that with silver quarters. The clerk told me that they couldn't accept those except at face value. And the same is probably true if I had brought down there a 1 ounce gold piece, $50, which now sells for around 1,900 Federal Reserve notes. So at the time, the clerk actually signed a document I gave her stating that they could only accept it at face value. And I immediately whipped it off to the local dumbass and demanded that he file charges against me for a willful failure to pay the fine. 18 years later, I'm still waiting. Never going to happen because they can't go in there and define dollar without giving the game away. It's a lot of power we had with that one issue, let alone other ones that you find in my document packets. By the way, send me an email, youwinincourt@gmail.com. I'll get the information out on the packets I have, how you can learn from them and go into court and take care of business yourself, like what I do. Never been beaten. Even the South Carolina felony case, shut them up in 30 seconds flat. So that said, getting back to the proposition here, that's at least a good start. And if you release people, especially with misdemeanors, for crying out loud, there's no reason to be in jail on a misdemeanor, especially when the Supreme Court has ruled. Arger Center v. Hamlin, 407 U.S. 25, page 40. Exact quote. Let each judge know at the start of a misdemeanor trial that no jail time can be imposed, though local law permits it when the accused was not represented at trial. How the hell can they keep you in jail for 1 day under these circumstances, let alone for a year or longer, since you can't post bail? I'd love to get that question to the 9-0 parts, and maybe I'll just do a petition on that and see if we can get them to answer that one. I'd love to hear it. That said, on this particular Prop 25, you certainly want to vote yes if you have the opportunity to do it. Not that I vote on anything. And by the way, I've never, ever voted any election whatsoever, long before I understood that there was no such thing as an election in territories. But just coincidentally, I guess, I've never voted, never registered, never nothing. But if you are, that's one you can vote on and maybe potentially make a difference and take a lot of power out of the hands of these black robe bastards and dumbasses of district attorneys that keep you in jail with absolutely zero reason and no jurisdiction to do it. So that said, like the videos, subscribe, tell your friends, get the word out. The more of us that understand these issues and go into court and start invoking our rights and across a wide spectrum, Americans, Africans, Asians, the quicker we get these bastards off our back. Thank you.